and we need to.
Welcome everybody, and you'll see the eviction notice up here on the screen. That's basically because we're going to be talking about eviction matters today. So welcome to Spin Legal. It's March 5th, 2025, episode 56 with Angela and myself, and we're partners at Invictus Legal. And tonight our topic is my tenant has not upheld their agreement to pay rent arrears. So think about that one, and we'll be talking about that tonight. So if you need to contact us, you can do so at 905-688-5598, or you can email Angela at angela@weareinvictus.legal, or myself at peter@weareinvictus.legal. And the website is https://weareinvictus.legal. Okay, so there we go. And not quite the way it's done in Ontario, but it is, it is expressive, isn't it?
Yeah, exactly.
All right. Normally you'll get the notice if you're evicted. If you're going to be evicted, it won't say eviction. You'll basically get a notice through the mail or through your email that will basically come in an order. It will be an order from the landlord and tenant board.
And then the sheriff will send you an email about what time and date they're coming, when you're prepared to, when they want you to leave.
Yeah, exactly. So that's the kind of thing that will happen. You'll not get so the first you'll hear it, it's assuming you didn't hear about it because you didn't go to your hearing, at the LTB. Now you've got this notice that comes through the door. It will come through in a white envelope that will come from the landlord, from the Ministry of Attorney General, and say Tribunals Ontario.
Yeah.
And it will say Landlord and Tenant Board on it. And so that's the nasty envelope. It doesn't say notice of eviction on the envelope.
It says order, or it'll say notice of hearing, or it'll say notice of hearing. If they're just giving you a date of some kind of notice of hearing that's going to happen. And when you need to do it, and they'll also give you a clue as to how to get onto the hearing so that you can participate.
Okay, so if you're a landlord and you're if you
are a tenant,
if you're a tenant and you owe the landlord money, what are your options?
Well, basically, you either pay the money up front, get it, however you can to pay the money. In many communities, there's something called a rent bank, and there's other types of options where you can turn to, especially if you're going through a temporary but very difficult period, where you could keep that up, and then you can talk to your landlord that you're doing these things so that you can catch up on your rent, because this happens a lot. Where someone has a temporary but difficult period. Maybe there was a job loss or a temporary illness in the family or something like that, and you needed to do that. The other option is to discuss with your landlord ahead of time to enter into a repayment arrangement where you'll be paying your rent every month and perhaps some additional rent every month until your rent is completely covered. So if the two of you can sit down and come up with that, and that again is optional. And landlords and tenants, they often do that. I mean, it's not something that's around. It depends on how much you owe. Like if you owe $40,000 or something, and it's not likely to happen.
Well, yeah, but there have been instances where $40,000 has been done there's been a repayment plan for $40,000. Now, true that it's so $500 a month. That's a long time to wait for the money, and many landlords wouldn't typically wait to have their rent arrears paid more than a year, and understandably that they would not, because a year's typically the amount that is dealt with, right?
Mm-hmm. Sometimes a tenant would say they have something coming, like maybe they have a lump sum of money coming from somewhere. They're getting paid a severance from a
Yeah,
former employer, or a
yeah.
personal injury settlement, or something that they can use to put toward rent arrears. And that's happened too when you have a large amount, and you can use that and say that you should be able to get that. Hey, but the trouble with that is sometimes you don't know when that's going to be coming in.
Yeah. Okay, then the other question from the flip side of it. So you're a landlord and your tenant owes you money, owes you rent. What are your options? And here, I think it's going to depend upon your tenant's ability to pay. Um, you know, the
Their history.
exactly how much they owe, etc., etc. Hey, if they owe less than $10,000, you're probably more likely to be able to figure out a payment plan than if they owe they owe $50,000.
Yeah. Yeah, and it's important that you try not to let it get to $50,000.
Yeah,
And I've
exactly.
been trying to bug
And
it so that the board would start having its hearings earlier, like within 4 to 6 weeks, so that it will never get to that point of
well,
$50,000.
the interesting thing is about it when we had the backlogs during COVID time back in 2020, 2021, 22, and 23, before hearings started to get probably 2023, hearings started to happen at a proper pace. There'd be a fair number of them. You'd be able to get through certain hearings. There was a massive backlog of hearings. So by 2023, you were starting to get hearings, L1 hearings, the rent arrears hearings were being held probably inside 6 months, then within 3 to 4
Yeah,
months,
yeah,
sometimes if you were lucky,
yeah.
right? And most of the time prior to that, between 2020 and 2022, there was a massive backlog on these L1 applications on the rent
And they
arrears.
were closed for a
Yeah,
while. Landlord tenant
they
board
were.
closed during a certain period of time, and tenants took advantage of that. And then many tenants ended up owing like a year in rent.
Oh, yeah. Well, back in 2021, I had a tenant that owed I think $24,000, and I'm not talking Toronto here, right? I'm talking in Niagara, a tenant that owed $20,000. And the reason, by the time they were evicted, and part of the reason was that the landlord and tenant board went through this phase of, we've got to accommodate the tenant, we've got to appease the tenant, and they appeased them 3 or 4 hearings, and then you're out. Right?
And by the time
You're
they're out,
out of
it's
here.
$50,000, and the landlord's probably out of their own house because they can't
Yeah.
afford the mortgage.
Yeah. Now the landlord and tenant board's a bit more reasonable. We're getting hearings at a lot faster rate. Okay.
Yeah.
So there are several options if you're in a situation, and whether you're a landlord or a tenant that owes money, there are options. You should
Yeah.
be, it's important to understand that.
Yeah.
There
As a
are,
landlord, as soon as they start owing you money, the first thing you need to do is serve them an N4.
yeah,
Let them know how much money you owe. Okay. So that comes at the second day or later.
yeah.
Okay, of the month. So they have to pay on
And
the
don't
first,
leave
and you
it.
pay them on the second day.
Yeah, serve it on the 2nd or the 3rd or the 4th. Don't leave it till the 25th.
Yeah, and don't leave it several months, and let
Yeah,
several
yeah.
months go by before you start acting on a rent
Go talk
arrears.
to, as a landlord, go talk to a paralegal. The cost is well worth it. And as a landlord friend of mine keeps saying, remember, landlording is a business, and there are certain expenses that come with a business, like hiring a paralegal
Yep.
to get your eviction done.
And we are
Right?
completely tax write-offable.
Yeah, absolutely. It's a complete tax write-off. Okay, so if you're either a tenant who owes money, or you're a landlord who is owed money, and you've done the relevant things, you issued the N4 application, you've now got an L1 that's come current and active with the board, so you've made an L1 application, and you could, at this point, you could negotiate an agreement before the LTB hearing. You could either go to a mediator who's independent, or you can actually hook up and choose mediation on one of the options on the board site, isn't there?
Yeah, exactly.
Right.
So there's like sometimes you can do this before a board hearing, right? Just where you just sit down and you fill out one of the forms. It's up on the landlord tenant board site, and you can fill it out, and tenant will pay the rent every month, plus at another time of the month they'll pay another chunk of rent to you until it's all paid off with the arrears, right? And that sometimes works out because a lot of landlords don't want to get into matches with their tenant at the landlord and tenant board. They don't like to do that, and some tenants don't want to do that either. And especially if the tenant has a history of paying rent on time and has not had problems before, but then suddenly
Mary's been, from the landlord's perspective, Mary's been with me 19 years, and now all of a sudden she didn't pay me rent in December, on December 1st, January 1st, February 1st. Well, first of all, I'd be saying, why are you dealing with it now? I'm just trying to be kind to her, right? You give her the N4, you give her the N4 right up the front, you do your L1 right up the front. Now you can negotiate, because she will have your application in front of her, and Mary can call somebody, call a paralegal, or she can, negotiate with somebody, or maybe you offer negotiation with her. Maybe you do want Mary as a continuing tenant because, hey, she's always been on time. The trouble here is what you don't know is what Mary's been going through the last 3 months.
Yeah, sometimes you may just want to talk to the tenant. I said, is there an issue? Is there something going on that I need to know about?
Yeah.
Okay? Sometimes maybe there was a single income in the household, and that person who is a single income earner lost their job.
Yep.
You're trying to find another one.
Another one is, hey, my husband was the guy who brought in he paid all the rent, and he just died last November.
Yeah,
so,
and
that happens.
Forget to report that.
Yeah,
right?
and with everything else that's gone on in the aftermath of a death, people forget to tell you things like that.
Yeah, and they don't know. Yeah, and the thing is, it's especially if you're the one who's grieving. Hey, this happens. Hey, so, and the thing is, the landlord doesn't know that. They can't read your mind.
Yeah.
Okay? So this is something that's very important. So things like this happen, and we need to get this sorted out. And many times they can come up with an agreement.
Yeah, and often, things like losing a job, that's hard. Losing somebody you love, that's horrific, right? I would not wish it upon anybody. And if you happen to be a person who's grieving through such a situation, our condolences are with you.
Yep.
Right?
Yep.
Be
and
very clear. We don't wish that.
And the landlord, because when you both have the same information, and then you can start saying, okay, now how can we work this out?
Yeah.
And if you're a tenant and you could still manage the rent, and if you feel you could still stay there and manage the rent, that's fine. Right? Then figure out a way that we can pay the back arrears. Right?
And you've got an option to negotiate an agreement before the LTB hearing. As I say, click up on the top right of the portal when you log in there, put your application and say, I want to negotiate.
Yeah.
Right? You can make offers. And for example, if you owe $5,000, maybe the offer that you can make is, I can't pay you the $5,000, but I can pay you $4,000 over the next 6 months. Is that acceptable?
Yeah.
Right?
Yeah.
That type of offer shows that you've got willingness to actually handle the problem.
Yeah.
And although negotiations between the parties can't be used as evidence for an LTB hearing, it is good to know that you've started that communication.
Yeah, and you also know where each party stands.
And in fact, actually, what might happen at a board hearing is the adjudicator would say, okay, Mary, have you done any form of negotiation with your tenant, Angela? Oh, you have. Okay, that's good to know. I don't need to know what has happened at that in those negotiations, but just to know that you have negotiated. Did you have an opportunity to speak with a mediator today? All right. That then leads to to that answer, which can help the adjudicator know your position.
Yeah, and often too, you can go back into the mediation room and solidify what you've been talking about.
Yeah.
Okay, so there could be some kind of thing, and having a mediator. They don't seem to have these mediators that much anymore. I don't know what's happened to
I
them.
think they do. They certainly do for L1 hearings. The
Yeah.
last block of L1s that I've been to, they've had mediations there.
Mm-hmm.
Right. It's some of the other ones that they don't have the mediators too. Right. But okay. So we talked about negotiating agreement before the hearing. You've got an option to mediate at the hearing. So you've got a dispute resolution officer, or called DRO, who chairs this. And the DRO, their specialty is purely and simply finding a negotiated settlement.
Yep. If both parties are willing, go in, and then the mediator will work with you.
Yeah.
And many times they come up with even creative solutions that may not necessarily be something that can come up in an order, but would be something that that the two parties could live with.
Yeah, absolutely. Yeah. And for example, some form of creative solution might well be based upon things like, oh, my husband died. I can't afford to continue paying the rent for this 3-bedroom place, but could I move to a 2-bedroom place and maybe pay 2/3 of the rent? And it says, yeah, actually, just to happen, we've got the one unit around the corner from you on Maple Avenue that's just become available. How would you fancy moving in there? That's not the kind of arrangement that an LTB adjudicator can even come up with. He wouldn't even be able to come close. He'd be saying to you, it's outside my scope entirely.
Yeah, they can't make an order and say, now the landlord shall move this person to their 2-bedroom. They can't do that.
No, it's way outside the scope of an adjudicator's position at the LTB, but a mediator could do that.
Yeah, mediator could do it, and they could write up any order.
Yeah, and the interesting thing is
between the parties.
Yeah, and the interesting thing is about that is that because it's an order, that order becomes enforceable if there's a breach of contract.
Yeah, and these are orders that are confidential.
Yeah,
each party takes them away with them, and it's not brought up to the hearing unless the parties choose to bring up to the hearing. Because if it's just something about paying rent over a period of time, that sometimes can be brought up to the hearing under a consent order.
Yeah,
which appears before the adjudicator, and the adjudicator makes an order based on a consent order.
Yeah.
But these other hearings where there's something unusual ordered, but both parties agree, it gets written out on a piece of paper, gets printed out, and each party gets that. The landlord-tenant board does not receive that, but if there's a breach of it, then either party can reopen it.
Yeah. Okay, so let us talk, therefore. I have a mediated order. And so a mediated order comes typically 2 weeks after the hearing. Right?
Mm-hmm.
So they're typically cranking these out fairly quickly. I've
had same-day orders.
Pardon me?
I've had same-day orders with some mediators.
Yeah. I would say generally I'm about 3 to 4 days in most of the ones that I've gotten.
Yeah.
Yeah. 2 days, 1 day is exceptional. I typically say next week.
Depends on the workload. What the workload
next week is. Yeah. And most adjudicators are fairly good about what their workload is. The next week item that I've had, promised today on a hearing. So that was promised next week. So I'm hopeful. Usually an adjudicator isn't going to lie on when they're going to get it. Okay. So an arrears. So now let's say you've got $5,000 worth of arrears. and you've agreed to pay an amount of money over the next year to recover those, to bring those arrears back into line.
Yep. Say $500 a month or something like that, over and above your regular rent.
Yeah. And for example, one of these agreements could well be that they do not give you the typical rent increase that comes in March of every year. They don't give you the rent increase for next year at March.
Mm-hmm.
Right? That they delay the rent increase by 3 months in order that you can finish paying the amount before the increase comes into play.
Yep. So there's a lot of different ways of sorting that.
I've done that kind of one before, because the tenant was concerned that if the rent went up by 2.5%, that would mean that she would be therefore kind of out by, $40-$50 by whatever the rent went up by.
Yeah, they have very tight budgets, some of them.
Pardon me?
Some of the tenants have very tight budgets.
Yeah, exactly. So the landlord in that particular case was saying, yeah, okay, I will delay by 3 months the notice for when the rent goes up, and and that was an acceptable thing, right? So okay, so you've got a mediated order, and those are said typically coming within 2 weeks after the actual hearing. So the next big question for anybody, really, whether you're a landlord or a tenant, the next big question is this: what happens when there's a breach of the order?
Well, you got a mediated order in your hand that came from the board or from the mediator.
Yep.
And you look at that, and then there's a breach of it. Then what you do is you go back to the board and you do an order. It's either reopening or you register a breach.
Yeah.
And then what happens is there is usually an order. There's a hearing that comes up, or there's an ex parte hearing, depending on the type of breach that took place.
Yeah.
Okay. So if there's what they call a Section 78, it's ex parte, which means that an adjudicator can write up an order and saying that there was a breach, and then therefore you're going to be evicted. And you're
typically. But Angela, you're jumping ahead. Typically, the type of breach is that usually it's on the tenant party. The tenant does not pay or doesn't pay the full amount. So they were
late or $1 short. Yeah,
exactly. So you were supposed to pay. You agreed to pay $561.22, and instead you paid $530.
Yeah.
Right. And the day late and dollar short is very important, because if you paid, instead of 31 cents, you paid 30 cents, they'd go, yeah, well, I don't care. Right.
Mm.
A penny here or there, they probably wouldn't care on most.
And that depends on the landlord too.
Yeah, I know.
Yeah.
But if you don't pay the full amount, and remember, in here on the first of the month, you're paying your $2,627.62 for your normal rental payment on the first of the month, and on the 12th of the month, you agreed to make a payment for an amount of the additional money, right? So both of those dates have to be complied with. Your first of the month, you must continue to pay your rent. On the 12th of the month, you must pay the additional amount.
Yep.
Right. So that's an important factor there.
Yeah. And then what can happen is the tenant can be evicted. The tenant still has an option to set aside the ex parte order.
Yeah. So the landlord can make an application to the board, which will basically, as Angela said, will be heard ex parte. What they will do is the landlord will put up evidence to say, hey, here's the order. And the order is clear that on the 12th of February, the tenant shall pay $561.32, and and show evidence such as no such amount arriving in the landlord's bank account on the 12th of February, Now, of course, you can then go to the board within 30 days to say, hey, you can make an application within 30 days to say they haven't paid.
Yep, exactly.
Right?
And that can arrive at that. And by the time that ex parte order arrives, the landlord will get a copy and the tenant will get a copy. So the landlord can act on it, but the tenant can also apply within 10 days for what they call a set aside order, which
Yep.
means that if there's a reason why they breached the order, okay, like say for instance somebody died in their family, okay, and they had to leave, and they were just going through so much grief, or if they got sick and they're no longer able to work. So there's a number of things that could cause them not to be able to adhere to that order. So they can go back to the board and revise that order in some way. But it doesn't always mean they could. Okay? It's up to the adjudicator again.
Oh, yeah.
Because many times this was done like with the help of duty counsel, and it's taken seriously because and if there's a lot of money that's owed, because generally the more money that's owed, the more the board would side with the landlord. So you have to be very careful with that.
And typically, for example, and doesn't matter how much is owed. Say that you owe $6,500, and you make an agreement with the landlord that on the 1st of April, you will pay your normal rent of $2,200, and you will pay $620 in addition to that, right?
Mm-hmm.
And what happens is on the 1st of April, you don't pay your rent and you don't pay your overage, right?
Mm-hmm.
That's going to be pretty damning,
mm-hmm.
right? The chances of you coming out from that is slim.
Mm-hmm.
Right? And to be honest about that, just be very.
And adjudicators can kind of know that, they sort of instinctively know that.
Yeah,
right?
And I have seen people who have failed to pay on their first payment, right?
Mm-hmm.
And hey, you might forgive a person if they were a few days late on their, say they had 13 payments that they had to make and they were a few days late on their 13th payment.
Mm-hmm.
You might forgive them on that one.
Yeah.
Because now you're probably down to, from your $650, now you're down to $382.60 or whatever, because now you paid off everything but the last bit, and you're paying the leftover. If you're a few days late on that, there's probably not going to be an issue with that.
Yeah, exactly.
Work that out with your landlord if you're in that kind of situation, right?
Yeah, especially if the tenant has actually been paying all along.
Yeah.
So this is something that would work that way.
Yeah, and especially if you've just paid off $50,000, for example, and you're missing out on your $380 at the end. You don't want to be out of your rental unit because
Exactly. Because it'll cost you about that much to hire the sheriff and so forth.
Yeah, go talk to your landlord, figure it out, and get it done, right? And the last thing you want is really to have the sheriff involved.
Mm-hmm.
Yeah. Okay. So, anything else we need to add in terms of this situation?
Well, this is something where people can, it talks a lot about mediation, which the board is trying to encourage, because I think the board wants to have less cases appearing before them because it gets so much backlog. Okay? And if the parties are able to mediate, by more power to them.
Yeah.
But I would like to see the board actually have the hearings more closer to what they were when I first started practicing. Where I'd do an application and I'd have a hearing within the next 4 to 6 weeks.
Yeah, and I think that
people mowing $40,000, $50,000.
Yeah, and I think that when you withdraw an application, doesn't matter what type of application you're talking about, whether it's a rent arrears or some other form of application, if you've managed to mediate it, you've managed to come to a settlement with the tenant, or it's a tenant application, you've come to a settlement with your landlord. Make sure you withdraw the application. Obviously, if you send in the paperwork to withdraw it now, for a week's time, don't worry about it. Don't bother with that one. Just appear on the day and say, say to the adjudicator, it's been withdrawn. We've come to a settlement, and you don't have to go into the details of the settlement. You just say it's withdrawn.
Right? Yep, exactly.
And typically, if I was going in, if it was 2 weeks before a hearing, I'd be writing the withdrawal paperwork up. All right. A week away from the hearing, I'm going to appear.
Yeah, a lot of times you do have to appear, particularly if things happened yesterday.
Yeah.
Tenant pays up everything they owe. There's no reason to go to the hearing, but somebody shows up and says, look, we don't need to have a hearing. The tenant paid everything up. We're done.
Yep. Yep.
Yeah.
And the good thing about that is that when you're dealing with these kind of withdrawals and that, you can probably you'll get active on an LTB hearing block, typically about 5 to 9. You can typically be out of there between about 9:30 and 9:45. Be done and dusted. Mm-hmm. Everything's over with. You're clear. You got the rest of the day free. Well,
we used to love those back in the day when we had to go in person. We'd get in the morning in the day, and we'd had our L1 hearing and have everything done, and we were out there by 9:30, 10 o'clock, and we're done.
Yeah.
Okay? So, but nowadays, sometimes you do have to wait a little bit because they have several things. So now on the hearing dates, they have like all L1 hearings, all L12 hearings, different things like that, or all review hearings. Yeah. There's different things like that where they're trying to organize themselves better so that the board can be more efficient.
Yeah. And the good thing about this is that we get a situation with these types of hearings. And I think it was important that we talk about settlements and ways to agree things, because if the situation appears bad, and say, it's easy to assume your landlord wants you out, right? You owe him money, he wants you out. You owe him 3 months worth of rent, he wants you gone. Right, because everybody knows he can rent it out to somebody new for twice the price as what he's renting it to you at.
Yep.
Don't make such assumptions, because sometimes, you know what, you've been a tenant for the last 15 years with this particular landlord, and he might actually know. I like Mary. Mary's been a good tenant. She never reports any. She never has things like bed bugs or cockroaches or anything like that. She only ever reports when she's got things like a leaky tap. And I know that if Mary's telling me she's got a leaky tap, it's leaking.
And she'll be home when the contractor shows up. They don't try to cause trouble like that.
Yeah. And in fact, actually, the contractor can call Mary.
No.
Right. I'm happy that the contractor calls Mary. He just sends me the bill. I'm done. Right. Mary signs off to say the work's fixed to satisfaction, and and the landlord can then receive the bill and pay it up within a reasonable time. Yeah. And I think those kind of situations, that's a reason why the landlord wants Mary, because she's a good tenant. She doesn't punch holes in the wall.
Yeah, exactly.
She doesn't leave her car across the grass.
Right? Mm-hmm. Doesn't throw wild parties at 3 a.m.
Yeah, exactly, that type of thing. Mm-hmm. Those type of tenants may be paying less, but they are sometimes worth their weight in gold. Mm-hmm. Right? Even though they're losing you, technically they're losing you money. Mm-hmm. Right? But again, it depends upon who the landlord is, what their requirements are. Unfortunately, there are some landlords out there who are just, nope, I want Mary out. I want Mary gone.
Yeah.
Right. It is the way it is. And us as paralegals, we are looking at what the requirements are in each of these cases.
Because we do have to follow what our clients' needs are.
Yep. All right. Okay. And that's been a kind of quick run through with negotiated settlements and how you can do alternative things at the board. All right.
Yep.
So let's turn this one off, and I'm going to come to the bottom and just say, if you need to contact Invictus Legal LLP, you can do so on 905-688-5598. Or you can email Angela at angela@weareinvictus.legal, or me at peter@weareinvictus.legal. Go visit our website anytime you want at weareinvictus.legal. And with every part of any of these shows, Angela loves this last bit.
Oh, yes, my favorite, right? Yeah, what you heard today on Spin Legal, whether it's this show or others in the series, is not legal advice. Whatever we say on the show, that doesn't mean that this is what you need to do to go ahead, because that's not necessarily always the case for you. If you need legal advice, contact a paralegal or a lawyer. We'd like you to contact us, but do contact a paralegal or a lawyer.
And don't let this situation be, if you're a tenant, don't let yourself get to this situation.
Yeah,
All right.
don't let it get out of hand.
Yeah. All right. So thank you. Have a great day, and we'll see you again soon here on Spin Legal.